morning.
Good morning, everyone.
Good morning.
Welcome to Civil Procedure. It is what we're here for, right? It's Friday. We get to do civil procedure on Fridays, and that's why we love Fridays. And what is happening in your legal universe? Well, if you're able, through the bleary haze of second year law school, if you're able to listen to any news, you probably heard about this one, right? Where the Supreme Court, to commemorate the 9/11 terror attacks, not really, but on 9/11, issued what the headlines are saying is the big go-ahead to the Trump administration to totally change the rules for Central Americans who are seeking asylum in the United States. Rule imposed by the Trump administration, for those of you that don't know, is you have to seek asylum in some other country on the way here before you can seek asylum here. Totally new, totally different change to the way in which we do things here. The court, the California court, the lower court, the district court, says, no, you can't do that, right? And when a court says, no, you can't do that, because we can't read the news like normal people anymore. Now we have to read the news like lawyers. Right? When the court says, no, you can't do that anymore, what have they done? What is the procedural device that they've used? Probably, to tell the government it can't do something anymore. An injunction, right? So the district court federal district court says, no, you probably can't do that because it probably violates the Constitution. That's called a preliminary injunction. Right? And the difference between a preliminary injunction and a permanent injunction is that a preliminary injunction is preliminary and a permanent injunction is permanent, right? But those are the two different kinds that you can get. So right off the bat, if something really bad is happening and you want the government or any other defendant to stop it, you ask for a preliminary injunction. That's what the plaintiffs did in this case at the district court. The district court says, yeah, I'm going to give you the preliminary injunction. We're going to stop the rule from going into effect for now, and then we'll make a full ruling on the merits later, and maybe I'll enter a permanent injunction. Usually, if a preliminary injunction gets entered, it's a pretty good indication that a permanent one is going to be entered later. Is everybody with me? Right? The way the news reads is that this rule has been settled. The Supreme Court, when you see a headline like this, you're like, oh, the Supreme Court has just let the Trump administration do this rule, and so now this is the rule, and this is the law of the land, and this is full and final, and there's no more. This is Supreme Court, right? It's the last stop. Not true. So instead of reading the AP story, you, because you've got lawyer brain, terminal lawyer brain, you go to the SCOTUS law, right? And that breaks it down in some combination, some mishmash of English and legalese that might make a little bit more sense to you to explain what's going on procedurally. No reason why you wouldn't be able to keep up with that. The best part about these articles, as opposed to the AP, as opposed to the mainstream media articles, most of them, is that it links to the actual order. And when you look at the actual order, well, it doesn't look like a Supreme Court opinion that we're used to, because it's one paragraph long. This is the opinion, right? And then we have a 4-page dissent by Sotomayor and Ginsburg. If you go a little bit beyond the headlines, you see, okay, this is a one paragraph. Is it just that they don't care? They care so little about this issue that they're only going to write a one paragraph opinion? No. This is typical for the procedural posture that we're in. Why? Okay. So the federal district court has issued a preliminary injunction. And then what happens? This preliminary injunctive order is appealed to the Ninth Right? The Ninth Circuit gets a crack at this. Right off the bat. Right off the bat. What's unusual about that? It's a terrible way to ask that question. Preliminary injunction, I've already said, is a preliminary order, right? It's not a final order. So, for them to have a crack at the appellate court, don't they have to have a final order? We talked about this in class last time. It's got to be a fully final order that adjudicates all the rights that everybody's got in the case, and then you can appeal the thing, right? Usually, that's how it works, unless there's a statute that says you can go right to the Court of Appeals. And in this case, there is. Isn't this fun? Right? So when a court issues, and this is true of almost any court, state or federal, when a court issues a preliminary injunction, the defendant, whoever has been enjoined from doing the thing that they weren't supposed to be doing, has got the right to ask the appellate court to either lift that injunction or do something else, right? You get to run to the Court of Appeals right away to see if that injunction really should still be in place, right? Now here's where it gets fun. This is why we are here. They appeal up to the Ninth Circuit. Ninth Circuit says whatever it says, and then there's an automatic right of appeal on the issue of the injunction, the preliminary injunction that goes to the Supreme Court, right? And this isn't a petition for certiorari. You're asking the court to review the injunctive order. And they have to review it and say, yeah, it's okay to have this injunction in place, or no, it's not. Okay? So the Supreme Court here, in one paragraph, has said, no, it's not. Go back and litigate. That's what this means. Okay? It's very different. It's very different from Supreme Court allows broad enforcement of Trump asylum rule, which is technically true, but it makes you think that the whole thing has been fully and finally decided. It's not. They're just getting started. They're just getting started. Okay? So you'll see headlines that probably say the same thing, right, 6 months from now when it's all fully and finally briefed. But, see how this works? You file for your injunctive relief, you ask for an immediate injunction, this is an emergency, we gotta have it right away. Court says, okay, I'll give it to you right away, and then we'll sort out the rest later. The defendant says, no, I don't like that, I'm gonna go to the Ninth Circuit. You really think that injunction ought to be there? The Ninth Circuit says, yes, we really do. They go up to the Supreme Court. Supreme Court says, no, no, no. The other courts were wrong about that. No injunction. You go ahead and implement the rule as it is now, and we'll work things out on the back end. Okay? Go back and litigate. But while you're litigating, the rule's going to be in place. Yeah? This is fun, right? If you love this, you can be the procedure expert at your firm. Questions about any of that stuff? No? Okay. Then let's move on to discovery. We love discovery, provided we know what it is. What is it? Well, it's just a method of getting information that you need to be able to try the case. Right? Your civil rules, generally speaking, contemplate that there's going to be a trial, which in reality never happens. But that's the way the civil rules are set up. And so the whole idea behind discovery is, what is the stuff that we need, what are the processes that we need to go through to be able to get information from the other side that we need to be able either to make the claims that we have in our complaint or make the defenses that we have in our answer. That's all it is. That's all it is. How do you get information out of the other side? What are the devices that the court is going to allow you to use to get information out of the other side? How do you go about collecting it? You just go to their offices and start taking the stuff that you want? No. The rules tell you what you can and can't do. What do the rules tell you about what you can and can't do? Who knows? We haven't gotten there yet. We're going to talk about each one of these individual discovery devices individually. But what discovery devices can you name? I know you did some of it last semester. Yeah, Jessica?
Interrogatories and depositions.
Interrogatories, depositions. What else?
Requests for production of documents.
Requests for production of documents. Did you guys do some of those last semester or no? No? Yes? You don't know? Okay. Interrogatory. Request for production of documents. Depositions besides. What else? What are the ways in which you can do a deposition? Like there's different ways we can do depositions. Yeah. What are the ways you can do a deposition? Can you do a deposition in writing? Okay. Well, yeah, I mean, technically, I guess so. It's not really what I'm thinking of. We'll look at that later. No, for right now, yes, you can. You can do written depositions. Okay. You can do what we're used to, the oral depositions, right, in person, under the hot lights. Everybody's seen the Little Wayne deposition, right? Seen the Little Wayne deposition? I have to bring that for depositions. I showed that to you guys in my writing class. Oh man, that's the greatest deposition. And also be aware, we'll talk about this when we get to our deposition section, so you don't have to worry too much about it right now. There's a difference between trial depositions and discovery depositions. Okay? Those are two different things. Okay? How are they different? We'll talk about it. We're just not there yet. Just be aware that there is a difference. Such a thing as a trial deposition that you're intending to use at trial, but most depositions are discovery depositions where you're trying to figure out what the other side has and how you can use it in trial. Okay? What else? Anything else? Yeah.
Subpoenas.
Subpoenas, yeah, sure. You can subpoena third parties to get the documents that they have. You can subpoena employment records. You can subpoena medical records. You can subpoena inmate files. It won't work, but you can try. Right? What else? Request for admission. Yeah. Where are you getting that, Mr. Baker?
From Dr.
No. Where are you getting those devices from?
Rule 35.
Yeah, you're looking at when you look at the rules, right? There's this whole big chapter on discovery, and almost every one of these devices we talked about has its own rule. Okay, it's associated. Anything else? That's about it. The total list on the other slide. How is this different, though, before we get there, how is this different from discovery and criminal? How is civil discovery, because we're in civil procedure, right? So you're not using in your motions and your pleadings and your filings and stuff, you're not using the language of the criminal law. You're not saying somebody is guilty of something. You're not talking about the prosecution, so on and so forth. Keep that in mind. But how is discovery different? Those of you who have some criminal law experience, how is it different in the civil context versus the criminal context? Ryan?
Isn't it in civil procedure, it's like everything's discoverable that's not privileged or work product, and in the criminal procedure, that's not the case. There still might be things that are reciprocally discoverable outside of those two.
I think that's right. What is the constitutional consideration in criminal discovery?
You don't have to turn over anything that will incriminate yourself.
There's that, and what else? No reason you should know this unless you take the criminal procedure, unless you covered in common law already, which I doubt.
I don't
Yeah,
know
so
after that.
Fifth Amendment, right against self-incrimination. So that's going to play into discovery in a criminal context. There's also, yeah. Yes, exculpatory evidence. That's where I'm going, right? Brady violations, Brady stuff. Brady versus Maryland is the case. Okay? For those of you who are really interested in the criminal law. If you haven't got there in common law, you will. Basically says the prosecution has to turn over exculpatory evidence as a matter of constitutional law. They have to turn over exculpatory evidence to the defense. Here, it's the Wild West. None of that stuff applies, right? Maybe you have a 14th Amendment due process consideration that goes into civil discovery. Maybe, right? But you never litigate that. That never comes up. Whereas the constitutional stuff in the criminal context comes up all the time. What happens if you get a request, one of these requests we've talked about, and you're like, man, that's really uncomfortable. It's really bad for my client. I don't want to turn it over. How do you avoid it? Seek a protective order. We'll talk about it. Is it possible for you to just ignore it? Can you just ignore it and not turn it over? Well, technically, no. Right? Especially not if a judge orders you to turn it over. If the judge orders you to turn something over and you still are like, no, I really don't want to do that, what's going to happen to you? I think I heard it. Yeah. Yeah, you're going to get held in contempt. You may get sanctioned. It's going to be very bad for you. We'll talk about all that stuff. Interrogatories, just written questions, request for production of documents, exactly what it says. Give me these documents. Request for admissions. Admit that you ran the red light. Admit or deny. Right? Pares down the issues for trial, in theory. Admit that you had insurance at the time of the auto. Admit. Simple. Depositions with the court reporter, writing down every word everybody says, maybe with a videographer, under oath, or written depositions. By far, more common is the oral examination depo, right? The in-person depo. Sometimes they can be done in writing. You don't see it very much. What I also don't see very much in my line of work, or in what we missed over here, are requests for inspection of land or something like that, right? So you can make a request to enter into a property and to inspect it. Maybe that happens a lot in some kind of litigation, not the kind that I've done. Independent medical examination, physical examination, psychiatric examination. You can order a party to submit to a medical examination. Why would you want to do that? Why would you ever need to do that? Yeah?
See if they're competent to stand trial.
See if they're competent to stand trial? Maybe. We don't care about that much, because if they're incompetent to stand trial, well, they shouldn't have sued us in the first place, right? It's not like a criminal case. Competency to stand trial in a criminal context is very different. Brian?
To review damages.
Review damages, that's really the thing, right? This guy smashed me over the head with a beer bottle, and I lost sight in my eye, and hurts really bad. I'm never going to be the same ever again. Well, I don't know about that. Let's have somebody else check you out and verify those facts, okay? Let's see if you're really hurt as bad as you say you are. Expert stuff is on another planet. We'll talk about it later. And subpoenaing documents from non-parties, right? That's pretty simple. You send over the subpoena, ask them for the stuff. If they don't want, let's say you represent a business, just to sort of take this side venture here. Let's say you represent a business that receives a subpoena for 80,000 pages of records. And you're like, we're not part of this litigation. We're not a party here. We're not a defendant. This is between two other completely separate people. And yet I've got this subpoena sitting in my lap. do you have to respond to it? What do you think? It says yes, you have to respond to the subpoena. Anybody say no, you don't have to respond to the subpoena. You got to do something. What if you don't want to turn it over? Do you have to just turn it all over if you get the subpoena? Who's got experience with this? A little bit. Do you have to turn it all over? Just give them the 80,000 pages worth of stuff? What can you do?
Can you file a motion to quash?
Yeah.
Or a second order?
Good. Yeah, you guys are good at this stuff. Yeah. You ask for relief from the court. That's basically what I'm getting. We'll talk about what that relief consists of. So you go to the court and say, look, we don't want to give them all this 80,000 pages worth of stuff. Why do we have to do that? And the court will either say, yes, you do have to give it to them, or no, you don't. Okay? Breaking down the different pieces of this gigantic monster rule that we will be referring back to for the next couple of weeks. 26. 26A tells you what you have to disclose to the other side. 26B tells you the kind of stuff you can get from the other side. Let's look at 26B1, because this is some language that pops up throughout the rules, and it's, I think, important that we have a handle on. So we'll look up our rules in America's search engine Bing. The first thing that comes up is this Cornell thing. Right, parties may, see if you can see this, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim for defense. Pay attention to that language because it comes into your discovery stuff, your discovery requests, and your objections to those discovery requests quite a bit. I think, Ryan, in your earlier answer, you already touched on it. What's a non-privileged matter? Or better yet, a better way to ask that is, what's a privileged matter? What might that be? Give me an example of a privileged matter that is not subject to discovery. Yeah.
An attorney's personal notes.
Attorney's
Strategy.
personal notes.
The strategy.
What is there a term for that? Attorney's personal notes.
Isn't that
Work product.
Work product, that's what it is. Very nice. Work product. That's a big one. The other really big one is.
communications between a client and a lawyer in preparation for litigation?
And is there an easier way to say that though?
Confidential communications?
Attorney-client privilege, right? Attorney-client communications of any kind, not just in preparation of trial. Not just in preparation of trial. Okay? Of any kind. You don't turn over your emails to your client. And then relevance looms large here too. So just keep track of that mentally, right? We'll talk about it more. But the two big privileges, work product privilege and attorney-client privilege. Okay. Got it? Work product privilege, attorney-client privilege. Keep track of those. Okay? Those are really important to your life. They're going to be really important to your life as a clerk and a first-year lawyer. If you're working on civil litigation, those will be your friend. Or your bitter foe, but you have to know that they're out there. And then, is it relevant to any party's claim or defense? Now that is really what makes litigation fun. Okay? Relevance. Because it might surprise you to know that the parties often differ on what is relevant to claims and defenses and what is not. So do we spend a lot of time arguing about that when we're in the discovery phase? Oh, yes. Yes. Yes, we do. I'm not turning that over because it's not relevant to any claim or defense. Well, actually, I think it is relevant. And so the court has to get involved and they get grumpy about that. 26C tells you what happens, what you can do if you don't want to answer a discovery request that has been propounded on you. get in depth on that. 26D basically tells you when can you start doing discovery. And what does 26D tell us about when? Because I'm sure you've committed this entire rule to memory by now. What does 26D tell you about when you can start the discovery process in federal court?
Is it after
If it's not up there, you might have to look at the rule. Yeah.
Is it after initial disclosure? Or do you need it?
Check this out. Scroll all the way down from C and D. Party may not seek discovery from any source before the parties have conferred as required by Rule 26F. And that's clear, right? You have to jump all the way down to 26F. You go on this wild goose chase. Basically, you can't start doing discovery in federal court until the court says so. Right? That's the best way to remember this. But that's just federal court. Right? So in the federal court, you can file your complaint, and that complaint could be sitting there for quite a while, months, before you ever serve the first discovery request. Really? You can just sit there for months before anything happens in that case? Yeah, the wheels of justice turn slowly. Which requires a lot of patience, unfortunately. Now, Kentucky. Different story. Look at 3301. First of all, what's the counterpart before we even look at 3301? 26D, what's the Kentucky counterpart to 26D? Huh? CR. What do you think? I mean, take an educated guess. Look it up. CR 26 dot
4.
4, right. 26.04, right? Have a look, if you can get there quickly, at CR 2604. Tell me what the critical difference is between Federal Rule 26D and CR 2604. You should see it right. You should see it right away. Are you guys really that burnt out this week?
Yes.
Really? What's going on? You got journal articles due or something? What's happening? No, nobody's doing that yet. This is simple. This is simple. We're in the easy stuff. We're still in the easy stuff.
Start at any time.
That whole timing section is not there, right? That whole timing section is not there at all. Now go look at 3301 where you have the Kentucky rules. I said FRCP, but that's wrong. Kentucky Rule 33. What does CR 3301 tell you you can do? It's something pretty specific, and it's an important distinction. Remember where we were. 26D says you wait to serve any discovery request until the court says it's okay. Yeah.
3301, it says that once the actions, once the case is made, that you can serve on,
Yeah, what happens? You're there, you got it. after service of a summons. Does that mean you can send a set of interrogatories along with the summons and the complaint and serve that on a defendant? Is that what that means? There's a real diversity of answers on that. Look at the rule if you're not sure. If you're not able to read that rule and discern from that rule, you may have a problem on the final exam. That is, in fact, what it means. That is, in fact, what it means. You can, it's very different from federal procedure. You can bundle up whatever discovery requests you want along with the summons and the complaint and say, here you go, answer these. And answer the complaint, by the way. Okay? Those of you that are looking at 3301, are there any special provisions that come along with that? Anything extra? You can do this.
They
What do
give
you say?
15 more days.
They have 15 more days and 45 days to answer the interrogatories as opposed to 30. Okay? Put it right there in black and white, the rule. Go ahead.
Does that ever really happen? You know,
Yeah.
like when you serve your hardware,
Yep. Yeah. I wouldn't be spending time rating you guys over the hot coals on this if it didn't really happen. It does happen. And it's a good thing to know as a plaintiff's lawyer too, especially if you're used to federal practice, because you don't know that you can do that unless you go and look at the rules. You can. And you can get things started pretty quick, which can be a problem in the state court. We'll see. 26E tells you when you have to fix the stuff that you've already disclosed, when you have a duty to supplement those responses that you've already made. In other words, 26F we'll talk about. How do we begin this whole thing? How does discovery get off the ground? Have a look at F3E. And when we look at this case management plan that I'm about to show you, you'll see why this is so important. Because as you read this, if you read the entire rule, you're probably thinking to yourself, oh my God, there's so much here to comply with. There's like 14 days and 30 days and 90 days and 21 days, and how am I ever going to keep track of all this stuff? You're not alone, okay? And because of this language right here, you can get together and agree with the other side, or even if you don't agree with the other side, the court is going to tell you what changes should be made in the limitations on discovery imposed under these rules or by local rule, and what other limitations should be imposed. What does that mean? It means that all that stuff that's there in Rule 26 in most federal courts is not going to be exactly what it says in Rule 26. You're going to change it at the beginning. And you're going to make a timetable that everybody can live with, and that's very clear in that case management plan, the final version of that case management plan that I put up on Blackboard. Everybody saw that, right? If not, you're going to. Okay, so that's important. This stuff gets changed. And then 26G just says, don't forget to sign all your stuff. Right? The case management conference is the first thing that happens. The court will sua sponte. Sua sponte, what does sua sponte mean? Come on, you made it all the way through first year. Sua sponte, by itself, set the case management conference. This is, we're in federal land. I'll talk about the state here in a minute. The federal court sets up the case management conference. Judge determines basically all the dates that are going to apply in your litigation, and then signs the order that has all those dates set forward, which starts off as that uniform case management plan in many jurisdictions. Okay? when you do these case management conferences, you'll have the judge or the magistrate on the phone, usually, and they're usually pretty short. Does everybody agree on all these dates? Yes. Okay. Is there anything else we need to take up? No. Everybody have a nice day. Okay. Not always. You can be taken by surprise if you don't know the lay of the land, as I have been before. Going to a simple case management conference on an employment case, employment discrimination case in the Middle District of Tennessee, which is Nashville, a court that I had not practiced in before. They wanted us to go down in person for this case management conference, which I thought was a little strange because most federal courts do them telephonically, and we proceeded to have a 2-hour case management conference where we hashed out every single day, all the claims in the lawsuit, all the defenses in the lawsuit, which I was kind of prepared to talk about, right? So know the lay of the land, but for the most part, especially Kentucky practitioners, this is going to be short and sweet. Real quick. You okay with these dates that are in the case management plan? Okay. Everybody go home. And you can change those dates along the way too, and that often happens. Some courts get pretty grumpy about it and some not. Just know who you're dealing with. So prior to, and I've referred to it a bunch of times and you've seen it already, prior to that case management conference, under the rules, 21 days prior to the case management conference, you have to confer with the other side. And the idea behind conferring with the other side, talking to your opponent, is that you can get all this stuff hashed out before it ever gets to the court in the first place. So you have some idea of what the dates are that you're going to be asking for, and most courts are going to require you to submit that case management plan document in some format so the court has something to refer to, and all the parties have something to refer to when you're putting stuff on your calendar, okay? Questions about that? It's easy, right? Easy. Case management plan is helpful if you're struggling with trying to figure out how 26 is supposed to work in the wild. In some ways, it's a little bit more helpful, I think, to understanding how the rules of civil procedure are supposed to actually work in practice. I think it's a little more helpful to look at a case management plan that's actually been executed than it is to look at the rule itself. Now, Indiana makes it easy. Right? The link that I sent you makes it really easy. Here's the uniform case management plan for the Southern District of Indiana. This is what we're going to use in all of our divisions in the Southern District. But we're just going to build off of this. They throw you a bone. In the Kentucky courts, not so much. Right? So what happens if you don't have a uniform case management plan to build off of? How do you put together a case management plan? This is not rule stuff, this is street smart stuff. So we're like, shit, we gotta put together a case management plan. How do I do it? You're resourceful people. What would you do? Yeah, that's right. Find another one that's already been filed someplace. Right? Because you know, at least if there's something that's been filed in the last year or so, it's easy to find in another federal case. You just get on Pacer and grab it off of there. Okay? All that stuff is available electronically, or get it from another practitioner. So if you're painfully shy like Ms. Greenwell is, that may be difficult, you can just pull it off of Pacer. And you can be pretty sure that that's going to work because it's already been put in place by some other court, right? Or at some other time. What the rules require you to do is to tender one of these guys 21 to at least talk to the other side about it. Maybe you talk to the other side and you can't come up with an agreement on anything. Does that happen? Yeah. Maybe you come to an agreement on some things and not the other stuff. And then you're in the unenviable position of having to go to the court of that case management conference and say, well, we didn't submit a proposed case management plan because we just can't get along, Judge. How do you think that's going to play?
Not very well.
You have to get along with the other side, right? You have to figure out ways to get along with the other side. And if you can't figure out ways to get along with the other side, you have to at least find a way to make yourself appear to be the most reasonable person in the room. It may happen that you were litigating against someone who was totally unreasonable. Fine. Make sure the court knows that. And as I've said, don't freak out about the rest of the time constraints in Rule 26. What we have is this uniform case management plan. Everybody see that? If not, pull it up with me, okay? You may want to anyway. 200%. Let's see how it goes. No, it's too big. Let's do that. A little bit, huh? This reference here, what is this referring to? What is that?
Southern District of Indiana.
Eh?
Southern District of Indiana, local rule 16.
Yes, yeah, the local rule. Okay. That's a reference to the local rule. Should you just breeze right by that and not look at the local rule? No, you should look at the local rule. Okay. Will you in practice? Probably not. But that's okay. We may learn some hard lessons. Review. Show. One important thing to know under the local rules where you're practicing is whether or not you take all this discovery stuff that you're going to generate throughout the course of a case, depositions, let's say you have a 200-page deposition, and 80,000 pages that you receive from a third party via subpoena. Do you file all that stuff with the court? Do you file it all with the court? Who says yes? Who says no? Who says it depends? Only two of you say it depends, 3, 4? I mean, that's always the answer to go with, really. Right? That's always the answer to go with. Because there's a local rule that covers this, right, for the Southern District of Indiana. You don't file discovery papers with them. But can you believe that there was a time up until, what, maybe 7 years ago, that we filed all the depositions that were taken in a case with the Jefferson Circuit Court? All those paper copies got filed with the Jefferson Circuit Court. That's a fairly recent development. During the time that I've been practicing, they stopped doing that. And it's because the chief judge ordered, please stop filing all this crap with the court. Right? You just hang on to it, and then when there's a portion of that deposition that you think I should look at, you give me that. Okay? But is it still the case out in the counties that you have to file all your depositions with the court? Yeah, some of them. Some of them. Know thy court, know thy judge. Prior to filing any non-dispositive motion, right? Non-dispositive meaning, you know what dispositive motions are by now, I hope, right? Dispositive motions, motions to dismiss, motions for summary judgment, motions that dispose of the case. Anything that's not that, the moving party must contact opposing counsel to determine whether or not there's an objection. So you don't just file your motion in the middle of the night. You have to ask the other side if they object to it. And say whether or not they do. That's a peculiar requirement of this court. And do people flout that requirement? Oh, for sure. But a good idea. If you can put something in a motion, it's because the court is constantly trying to make its own life easier, right? Courts have lots of work to do. And so if you can put in a motion, it makes your life easier too. If you can put in a motion, there's no opposition to this. The other side has no objection. It can be pretty quickly granted. And it makes their life easier. Federal rules, civil procedure, 26 initial disclosures. What are initial disclosures? Well, you're about to find out. Okay? You're about to find out under Rule 26A. 26A1 tells you all this stuff that you have to give the other side as a matter of course. That doesn't happen in state court. It just happens in federal. Some state courts might have that rule. I've never practiced in one. But in the federal court, there's stuff that you have to give out automatically. It'll be covered by your case management. Preliminary witness and exhibit list. You're like, how do I know what witnesses and exhibits to use if we haven't even done discovery yet? What's the point of this? What's the point of doing that? What's the point of sending a preliminary witness and exhibit list if you haven't even done any discovery? What do we think? Think like lawyers. Yeah. Giving them notice, you're helping to shape the discovery that's actually going to happen, right? You're helping to shape that discovery. You're helping to streamline things. Right? Civil procedure, civil litigation isn't about the art of surprise. There's a big long passage in your book, for those of you who are still reading the book. There's a big long passage in that. It's not like that. And in that way, it differs pretty significantly from a lot of criminal procedure that's out there. There's no element of surprise in civil litigation, usually not, right? You get to know, in most courts, pretty much everything that's going to happen before it happens. Yes?
With preliminary witness list, can you be vague? Like, can you just say
When you have to.
responding,
Yeah.
officers and emergency personnel?
Yeah, you want to be as specific as you can, but I mean, I think everybody tends to understand, unless you got a judge that's a total tyrant. Like, everybody tends to understand, we don't really know that much about it. We're just trying to get an idea of what this is going to look like in the future, right? Special damages, you have to file a statement of special damages. What are special damages? Have you heard this term before? You talk about this in torts? It comes up a lot. We need to know that. What are special damages? There's general damages, and then there's special damages. Anybody know? Well, no, punitives wouldn't be special. Yeah.
Isn't this the provable out-of-pocket expenses?
Yes. Stuff that, it doesn't even necessarily have to be out-of-pocket expenses, but it's stuff that you can definitely assign a dollar value to. I think it's a good way to think about it. It's just out-of-pocket expenses, right? But general damages, like punitive damages, are a good example of general damage. I would like the jury to give me as much as possible, right? In pain and suffering, and emotional distress, and punitive damages, and all these different categories of damages that we have. I'd really like the jury to give me whatever you want to give me. Great. $1 billion. But my lost wages I could table at $28,652.35. Right? That's special damages. My medical bills, $148,000.12. Okay? Special damages. General is like, well, shoot for the moon, jury. Think about it that way. But something you can table, something you can assign a definite dollar value to, as opposed to just hoping you get as much as you want. Final witnesses and exhibit lists. So you get to refine what you filed in your preliminary witness and exhibit list. What they say here, it is not sufficient for a party to simply incorporate by reference any witness listed in discovery or such general statements. Why do you think this shows up in a standard order in the Indiana Southern District? Because practitioners are doing this stuff all the time, right? I don't know who my witnesses are, but I'm going to list these three guys and anybody else on the planet. Also, anyone with the last name Smith and anyone of Lithuanian heritage. I mean, you'll see people try to use these blanket catch-all type of statements, and the court is saying we don't like that. Bifurcation of discovery. Bifurcation of trial. Anybody have any experience with that? What is a bifurcated trial? Yeah.
It's kind of like a separation of charges, but I don't know how that works.
Could be. You run into that a lot in criminal context. You have two defendants that are being tried for the same thing. The trial is bifurcated. Oh, we're going to do this guy's trial over here and this other guy's trial over here, even though it's the same crime. But it happens in the civil context too. So would it be possible for you to have a trial on liability and then a whole separate trial on damages? Yeah, you can do that. Yeah, you could do that. Why would you ever do that? It seems pretty wasteful, right? Why would you ever do that? Why would you ever have a separate trial on damages, separate jury trial on damages, than what you had on liability? Is there a reason you can think of?
Would it be like something to do with statute of limitations when you're still treating?
I mean, that maybe, but I don't think so. That's not really, at least that's not what I had in my head. I guess there could conceivably be a scenario where that arises, but I don't know. Probably not. No, go ahead.
Is it where they think the same jury that found liability wouldn't be able to fairly determine damages?
No, I don't think so. I mean, I think that if I have a jury that rules in my favor on liability, I kind of want that jury sitting, in the damages phase. And if the defendant says, no, it's no fair to have the same jury decide liability and damages, I don't think that's going to curry much favor with the court. Yeah.
One I saw that separated liability from like insurance claims.
Yeah, that could be a reason. If you separate liability, because you essentially then you have different pockets, right? But if you separate liability from damages, in the liability phase, then you don't have to trot out all your proof about damages. Okay? You could have a couple of days worth of proof on damages if you have a severely injured client. Right? It could take a lot to prove damages. So you might want to do that in a separate trial after liability has been determined, when you know the defendant is more likely to fold, and you may not have to jump through that hoop in the first place, right? Much more likely to settle the case under those circumstances. But it's rare. You don't hardly ever do that. ESI, right, electronically stored information, more and more courts are starting to issue orders that are more and more specific about this stuff. I've dealt with it a little bit. I don't know a whole lot about it, but I can tell you this much. This is the wave of the future. Almost nobody knows anything about it. And if you want to make tons and tons and tons of money, become an ESI. That's your money's worth for today's class. Go and learn everything that you possibly can about ESI, write articles about it, give CLEs about it. And lo and behold, you will never stop working. This is funny. I just point this out because it's a very funny joke hidden here in this case management plan, which is otherwise pretty dry. Court requires counsel to use the case management plan as an opportunity to seriously explore whether this case is appropriate for dispositive motions. Right? In other words, is this really the kind of case that is going to be subject to a motion for summary judgment? Do we really think that a motion for summary judgment is going to be filed in this case? Let's have a serious discussion about that. Okay. In fact, what is the percentage of cases in which a dispositive motion is filed?
More than none?
Yeah, I mean, I think it's 100, maybe more than 100% if that's possible. Right? Because if you're the defendant, you don't want to leave that procedural device behind. You don't want to, in most cases, unless you think you can get in and try the case cheaper than you can preparing and filing a dispositive motion, when you're trying to save your client some money, which would be extremely rare, right? Not extremely rare that you'd want to save your client money, but extremely rare that it would be cheaper to just go try the case. You've got to file a dispositive motion. You almost have to, right? You almost have to. Even though many of them are bullshit. Okay. Statement of claims and defenses is the stuff that you have to do right before trial. File your statement of claims and defenses that you intend to prove in trial, stating specifically the legal theories upon which the claims and defenses are based. No surprises, right? All the witnesses are known ahead of time. All the exhibits are known ahead of time. Now, might it be different in some state courts? Sure. All this stuff you know ahead of time, okay? In the federal courts, everybody's going to know. There's not going to be any surprises. Not likely to be any surprises. The Perry Mason moment does not happen. Select the track that best suits this case. Track 1, which nobody ever uses, says no dispositive motions are anticipated. Track 2, dispositive motions are going to be filed by such and such date. Track 3 is just a different take on that. You can read through that. Right. All issues raised, and this is interesting too, because this court limits you, and I think we talked about this earlier in the semester, this court limits you to one motion for summary judgment and only one, unless you go and ask the court, can I file another motion for summary judgment? That's important for the civil defense bar, especially if you love filing 5 or 6 motions for summary judgment in the same case, which some defense lawyers do. The magistrate judge sometimes plays a big role in these cases and sometimes not. Everybody know what a magistrate judge is? Yeah, some experience with that, maybe a little bit. Magistrate judge is like the mini boss. Yeah. The judge is the boss, and the magistrate judge is the guy that you got to fight to get to the boss. But the magistrate usually will conduct the settlement conferences, and settlement conferences are almost always ordered, right? Magistrate judge at least does that, and then usually will manage things like discovery. In some cases, you can turn over, if everybody agrees to it, you can turn over the whole case to the magistrate judge. Your judge would probably like that a lot. Turn over the whole case to the magistrate judge, say you try everything and you make all the decisions. You can do that, but everybody has to agree to it. The magistrate judge is sort of there. They're not a lifetime appointment the way the federal judges are. They're just there to help the judge. Requesting the trial date. Oh, and there's the referral to the magistrate judge section, and if everybody agrees to it. This lays it all out, though. Right? This lays out everything that's going to happen in the case. Oh, and separation of witnesses. Let me skip over all this. I don't know, maybe I want to talk about this. Stipulations of fact. Again, we're trying to streamline the process by submitting stipulations of fact and writing to the court. Like, we don't really need to spend 2 days on establishing the venue in this case, establishing where it happened, because everybody agrees to that. Right? Tell the court what you agree on so you don't waste any time on it. If you intend to offer any depositions into evidence. So sometimes you can take these depositions. Let's say you take the deposition of a witness and that witness dies before trial. because it took you 7 years to get to trial, which it often does. Then what? Well, that's an evidentiary rule thing, but you can, at least in theory, play that deposition or read that deposition into evidence or parts of it, right? And the reason that you want that ahead of time is because the court is probably going to pare it down. If you're going to play deposition testimony, especially if it was a discovery deposition, then the judge is going to say, well, you can read these pages, but you can't read these other pages. Like, do people really get up on the stand and read out of a deposition transcript at trial? When you really play a video from a deposition that's been all chopped up at a trial? Yes, you do. It really happens. That's the majesty of the law. You're providing all this stuff ahead of time. Again, there's no surprise. Trial briefs saying, here's what our trial looks like. Motions in limine. Remember, the most citrusy of all motions that happen before your trial that pertain to issues that you're going to be talking about in trial. Jury instructions, voir dire questions. Submit those ahead of time in the federal court. Right? Not so much in state court, but in the federal court, you're sending them the voir dire questions ahead of time, and the court conducts the voir dire. Everybody knows what voir dire is, right? Jury selection. You're even notifying the court of requests for separation of witnesses at trial. What's a request for separation of witnesses? Those of you that have done some trial practice stuff, I'll go over this with you. It is the single most popular request in any trial of any kind.
Sequester.
Not sequestering. But you're not letting witnesses hear the testimony of other witnesses. Sequestration usually refers to a jury. You're keeping the jury away from the media and the general public and all that stuff. The separation of witnesses is simply you don't let witnesses hear other witnesses' testimony. And you probably want that. Both sides usually want it. And that's it. All your dates, everything that you could ever possibly want out of a case is set forth in writing in this case management plan. They look a little bit different from jurisdiction to jurisdiction, but they're all basically like this. And then there's the language here that allows the court to just sign off on it. And it's an order. And it has all the force of an order, a court order. Right? That's typically how we do these. Now, what happens in the state court? Well, as with most things, it depends, right? But you're probably not going to have anything this detailed out of most of the state courts, certainly not in Kentucky. In Kentucky, it's the Wild West. You file your complaint, maybe you serve some discovery on the other side in most counties, and you're on your own. The court doesn't sua sponte set a conference. The court doesn't sua sponte do anything. You have to ask the court to do something. Right? The court is not involved in your litigation. You do it. You take care of it with the other side. And there's no hard date set on anything unless and until you ask the court for a trial date. When you're ready for trial, then you go to, and that's a good way to keep a case moving, by the way. If you're in a plaintiff's practice and nothing is breaking loose for you, you can't get anybody to write you any checks, start asking for trial dates. Because that moves the litigation along. Once you ask for a trial date, every court is different, but most of them, especially in the Jefferson Circuit Court, will issue you a trial order that says everything is due by this date. Okay? Witness list by this date, exhibit list by this date, dispositive motions by this date, so on and so forth. And they're all different. But you're not having to, I think the important takeaway here is that you're not having to scour the rules of civil procedure every hour of every day to try to figure out what your next deadline is. The courts, for the most part, set that out for you. Okay? And all this stuff is squishy. It can be changed if you need to change it. Questions about any of that stuff? We don't have time to write a case management plan. If I had an extra hour in here, I'd have you write one. Just know that. But if you want to write one, which I can imagine would be a pretty boring exercise for you, your infinite spare time, go ahead and you can email it to me. Otherwise, you are free to go. Have a good weekend.